Hi! Having discussed the adoption of treaties and the topic of reservations, I now want to move on to the question of what happens once a treaty has been ratified, once it is actually enforced. And this, of course, then pertains to, on the one hand, the application of treaties, and on the other hand, their interpretation. We are still squarely within the Vienna Convention on the Law of Treaties here, so once again, my recommendation: have a look at the treaty and its provisions as you go through this video and as you read through the chapter. Let's start with the question of treaty invalidity. Mostly to get it out of the way, it is exceptionally rare, and as Klabbers nicely describes, it has more of a James Bond character. It makes for a nice fictitious story, but rather it does not happen in reality. That said, there are two general instances in which a treaty could be invalid from the outset. On the one hand, if the state or its representative has been coerced into giving consent, so if the consent is not real and genuine, and of course that would defeat the very foundations of international law as we saw last week. And the other instance would be if the treaty violates jus cogens, so these peremptory norms that are applicable to all states and that are owed to the international community as a whole, and from which there is no derogation, and that of course includes treaties that would be in contravention to it. Apart from these exceptional circumstances, however, treaties are applicable and they are enforced, and the obligations that we find therein must be respected. Pacta sunt servanda, as we saw in the first video last week. And this means that any change or termination of treaty regimes, and this brings me to the reading question for this week, also is governed by the principle of state consent. One consequence of this is, of course, that states can come together, and if they act collaboratively, then they can actually change, suspend, or even terminate a treaty. This doesn't happen all that often, mostly because it is really difficult to create international legal obligations, and once they have been created, one or the other state is usually incentivized not to move away from a particular regime. However, if a treaty objective has been fulfilled, or if a new treaty is adopted that, for example, updates the obligations to the new circumstances, then of course the old treaty falls into disuse, and then we do have a change within the international legal obligations that were applicable between the states. Even rarer and much more problematic from the standpoint of pacta sunt servanda are unilateral terminations of treaties. This basically means that a particular state decides on its own accord not to service its international legal obligations anymore towards one or multiple states. This has happened in the past. One prominent example are the United States during the Trump presidency pulling out of the Iran nuclear deal, leaving behind Iran and the European Union states, who then had to decide whether the treaty was still in force and whether the terms of the treaty would still be respected. There are three circumstances under which a unilateral termination could be a viable possibility under international law, and I can only broach them here, so please have a look at Article 60 to 62 of the VCLT, which outline them in much greater detail. The first of these is that the termination is a consequence, a reaction to a grave breach by another party of the treaty. The second one is the impossibility of performance, so a state is just simply not capable anymore of living up to the things it promised under the treaty. And the third and last one is a fundamental change in circumstances, to such an extent that in fact the very basis upon which a state has given its initial consent now is removed, now is not applicable anymore. One final aspect to consider when it comes to the application of treaties, though we are moving here quite quickly to the question of treaty interpretation, is if there is a conflict of international law. So if in fact different provisions in different instruments seem to contradict one another. And if this is really the case, so to establish whether that is the case, we already need to engage in interpretation. But if this really is the case, there are different principles to deal with such a situation. Namely, there is the lex posterior rule, arguably the most important rule, which establishes that the later rule, so the instrument and the provision that was passed at a later point in time, supersedes the one that was passed prior, and we can see how this is in accordance with the state consent principle. The second rule that is sometimes applicable and can also be useful is the lex specialis rule. So here the question is, which of the two rules is more specific, which one is more specifically applicable to a certain legal question, and the more specific one is then overriding the more general rule. Now finally, let's move to the question of treaty interpretation proper, and specifically to Article 31 of the VCLT, which outlines the general approach that practitioners, including judges, but also academics, take to the interpretation of international legal obligations. And it's obvious that this is a really important question because at the end of the day, how we interpret a particular word or a sentence or a whole provision will make a difference in whether a state is considered to be in breach of international law or not. There are three general approaches to treaty interpretation, and they're not so much in conflict with one another, though they can be. But in most cases, they're actually applied simultaneously and brought together to find one most convincing, most plausible interpretation of a particular rule. The first approach is the objective or textual approach, in which we look, as the VCLT says, at the ordinary meaning of a word. So what does a word in a particular provision mean? And based on this objective meaning, we then interpret what the legal obligation is. The second approach is the so-called subjective or contextual approach, in which we try to figure out what the context is within which a particular provision was drafted. So here we look in particular at the travaux préparatoires, so basically the preparatory meetings and the minutes of these meetings to establish what a particular word provision meant to particular delegates and how they came together to agree on what substantively this particular provision entails in terms of legal obligation. And finally, we have the teleological approach, which is focused on the object and purpose of a treaty. So the question here is, what did the drafters intend? What were their goals? To answer this question, we can usually look at the preamble of a treaty, so the first part of it, where these objectives, these goals, a bit of the historical context is usually explained. And then what we try to do is to align what comes in terms of operative paragraphs, so the things that follow and that give rise to substantive legal obligations. We try to align those with these preambulary paragraphs and these overall goals. The teleological approach, and I will end on this note, has not been without its critics. States have, sometimes quite vehemently, opposed courts using the object and purpose of a treaty to offer very broad and very liberal interpretation of a particular provision. That being said, if we want to keep international law up to date, if we want to make sure that particular treaties can be applied in circumstances that were not initially foreseen by the creators of these treaties, then this teleological approach is in fact quite useful, and applying it will get us to places that the objective and the subjective approach would not. This concludes the videos for this week. I look forward to discussing the topic of treaties with you in class. Bye bye.